Dr. Rifai, a physician from Pennsylvania, is suing the U.S. Department of Justice and the DEA. The doctor is board-certified in internal medicine, preventative medicine, addiction medicine, neurology and psychosomatic medicine, and psychiatry. Having completed a neuroscience research fellowship and with over 20 years of experience, the doctor operates Blue Mountain Psychiatry. Born and raised in Syria, Dr. Rifai appears to be the latest victim of the government's racially biased AI-enforced algorithms. Despite having earned several honors and awards as a healer and authoring several articles on the practice of medicine, and with no history of any legal or ethical difficulties, Dr. Rifai has been targeted for prosecution. The state had sent in an undercover police officer to pose as a new patient with psychological problems. Then, the DEA issued an administrative subpoena for the doctor's records. Administrative subpoenas are supposed to be used for administrative purposes, but this one was delivered by 2 DEA agents who threatened to handcuff the doctor if he did not comply. Dr. Rifai sought the protection of a healthcare specialized law group. After assurances that the information would not be used for criminal prosecution, the records were produced. Now the DEA is arguing that crimes have occurred, overbilling and prescribing medically unnecessary controlled substances, ordering the doctor to give up his DEA license. Here is a secret of the incredible 99.4% win rate for the U.S. government in criminal prosecutions. They win so much because they threaten dire consequences if you demand your right to a trial, threaten your family members, and destroy your ability to afford a good defense. The fact that Dr. Rifai can still practice medicine and afford a high-quality defense team like the Chapman Law Group means they would be faced with a real trial. The easiest way around this is to put the doctor in an impossible position. As those of you who have been called before a medical board or DEA administrative hearing, trying to argue that you are innocent is useless. Like the Inquisition these procedures are based on, guilt is a foregone conclusion. Your only hope is to admit that you could have done things better and promise to mend your ways. The problem here is that anything the doctor says at the administrative hearing can be used against him in court at his criminal trial. The government has already filed a motion with the court to admit all records from the administrative subpoena and proceedings as evidence of prior bad acts. If the doctor invokes his Fifth Amendment right at the DEA hearing, he will lose his livelihood. If he does not, he could lose his liberty. The creation of these catch-22 scenarios, where a physician must choose between their rights and providing for their families and defense. The doctor's attorneys have filed a civil action alleging a violation of the Fifth Amendment constitutional right to not be forced to testify against oneself, a violation of the Fourth Amendment constitutional right to be safe from unlawful search and seizure, whereby records received for administrative purposes with an administrative subpoena, where the bar is much lower, should not then be used for criminal prosecution. In this case, threats of incarceration were used to coerce the doctor into acting against his constitutional rights, and then only after assurances were made to his attorneys that the documents would be used for administrative purposes only. According to attorney Ron Chapman of the Chapman Law Group, warrantless administrative subpoenas may not be issued against targeted individuals when investigating criminal activity. In accordance with United States v. Hosbach, 1980, he goes on to assert that the Constitution does not permit the use of an administrative subpoena to circumvent the Fourth Amendment, especially when the production is caused by materially false statements made by the agent serving the administrative subpoena. Further, subpoenas cannot be issued to uncover evidence to use in the criminal trial under Rule 404B. And lastly, government agents are forbidden from using such deceptive practices and issuing baseless threats to a person's freedom to ensure compliance with a subpoena, especially an administrative subpoena. But tragically, that is what occurred here. As a result, Dr. Rifai was deprived of his Fourth Amendment protection against unreasonable searches and seizures in violation of the Fourth Amendment of the United States Constitution. The Center for Medical Justice will keep an eye on this case and let you know how it goes. Until then, Always refuse any request not cleared by a competent healthcare specialized legal professional and know your rights. Thanks for listening and stay safe.